Hello, good afternoon. Welcome to Nature Connects, TNC in Massachusetts' webinar series that connects you with scientists, experts, influencers, policymakers, and our partners from the Northeast and around the world. Thanks for joining us today. My name is Steve Long. I'm your host. I'm the Director of Policy and Partnerships for the Nature Conservancy in Massachusetts. Today, we're going to take a look at the new law in Massachusetts that provides a more efficient and equitable process for land-based renewable energy siting and permitting. It also provides stronger environmental standards and enhances community engagement. We stand at a crossroads right now with renewable energy and the need to ensure that we're meeting our energy goals and our climate change goals and our conservation goals. And I'm going to just share a slide here before we jump in. So you can see our goals for today. So we need to ensure really that we have both healthy ecosystems and the energy we need to transition away from fossil fuels. And that really requires a balance between renewable energy and land use. And in the recent past, we've seen the need to reconcile the need between renewable energy and land use, especially with solar development. Many of our forests have been converted for solar arrays, which puts conservation and renewable energy in conflict. And the Massachusetts chapter of the Nature Conservancy was deeply involved and played a key role in helping steer the direction and development of the latest iteration of new law and policies. We served on a governor-appointed commission that proposed policy reforms, and then we advocated for those reforms in partnership with the Executive Office of Energy and Environmental Affairs. And those reforms are now codified into law. And our focus was really on ensuring that renewable energy projects in Massachusetts meet standards for new things that were not already codified into law, for biodiversity, for forest carbon, for community resilience and environmental justice, while maximizing the benefits to climate, conservation, and communities, what we call the 3 Cs. We also collaborated with our environmental justice partners to ensure a more robust and equitable process for community input and voices. The new process requires a pre-filing before a permit is drafted to weave together the science of site suitability and the lived experiences of communities for better siting, design, and operation of renewable energy facilities. So today, we're going to hear from the policymakers who helped make it happen and what the new law means and the next steps where you can get involved. We'll hear about why reforms are needed, what they entail, and how they were developed. So without further ado, I'd like to offer a warm welcome to our panelists. Our guests have each played a key role in ensuring the balance between developing energy infrastructure and ensuring better outcomes for people and nature. So today, we're going to be joined by Undersecretary of Energy from the Executive Office of Environmental Affairs, Michael Judge, who chaired the commission and is overseeing the implementation of the new law. And he served in this role since March of 2023. And previously, he served as the Vice President for Policy for the Coalition of Community Solar Access, managing its policy team and leading its policy advocacy at the federal level and across more than 20 states, in which members' organizations are active. We'll also be joined by State Senator Jo Comerford. She served in the Hampshire, Franklin, and Worcester district in the Massachusetts Senate since 2019. Her district comprises 25 cities and towns, stretching from Northampton to Ashburnham, encompassing the Connecticut River in Hampshire and Franklin counties, and nearly circling the entire Quabbin Reservoir. We'll also be joined by State Representative Natalie Blais. She proudly represents one of the most rural districts in the Commonwealth that includes 18 communities in 3 counties over 450 square miles. Natalie is the Vice Chair of the Joint Committee on Agriculture and she's also a member of the Joint Committee on Tourism, Arts, and Cultural Development, Transportation, and Ways and Means. So a tip for the audience before we turn it over to our speakers. As you think of questions for the Undersecretary, the Senator, and the Representative, please enter them in the question and answer box at the bottom of your screen. We are going to hear from Undersecretary Judge and our two Western Mass legislators before we take questions. So thanks so much for joining us today, and I'd like to pass it on to Undersecretary Judge.
Thanks, Steve. Happy to be here today. So I'm going to go through, let me just make sure I get this right. Okay. Folks see my screen? Okay. Okay. Okay, so I'm going to go through the process that we used to get to the legislation that Steve was just mentioning a little bit, and talk a little bit about some of the details of what's in there, and then briefly touch on sort of the next steps. So, a second. Oh, there we go. Okay. First of all, just to set some context here, I want to talk a little bit about why we sought to tackle siting and permitting reforms, and so that it largely stems from our clean energy and climate plan, clean energy and climate plans, which are developed consistent with state law to reduce emissions. So the Global Warming Solutions Act and the Climate Roadmap Act of 2021 require Massachusetts to reduce emissions by, well, we have to reach net zero emissions by 2050, but there's interim emissions reduction targets that are established before that. So for 2030, we need to reduce it by 50% relative to 1990 levels. And there's other interim steps every 5 years. We're setting new clean energy and climate plans. So consistent with those plans, we have some sort of general targets. Now, these are not mandated targets, but they're modeled scenario values that say, okay, if we're going to achieve the emissions reduction requirements that are required under law, this is how much capacity we would need to deploy by that date of these various resource types. So when we look at 2030 in particular, we're looking at roughly doubling the amount of solar that we have deployed, and a significant build out of wind, mostly offshore wind, and a significant amount of energy storage that's going to be needed, new energy storage that's going to be needed to integrate all of that. All of those resources are also going to require an electric grid that can interconnect them and move that power around. So there's a lot of utility investments that are required. In addition, we are decarbonizing our buildings and transportation sectors as well. And the primary strategy for that is electrification of end uses in the building and transportation sectors. So we're expecting a lot of growth in the amount of electricity that we're consuming over the next 25 years as well. And that's really going to start to pick up in 2030 and beyond. So we have these very large emissions reduction requirements that we need to meet, and we need to deploy a lot of clean energy and a lot of grid infrastructure in a very accelerated period of time. So one of the big barriers that has been identified is the existing permitting processes that we have in Massachusetts. I think generally speaking, the feedback we've received is that permitting processes are lengthy, they're unpredictable, they're sometimes duplicative. We've seen, for example, at the Energy Facility Siting Board, it can take between 1 to 4 years just to issue an approval to construct, after which projects still need to obtain all state and local permits individually, each of which can be appealed separately. And so we've seen situations where projects can take 10 years or so to get through the entire permitting process and just get a final decision on whether the project can move forward. So it's not working very well for developers, but it's also not really working very well for communities. I think communities feel they often don't have sufficient or impactful input into the siting of these facilities. They feel that they don't necessarily have the resources necessary to fully engage in the permitting process. It's complicated, it's confusing, there's a lot of different aspects to it, and it can be a little bit exhausting, I think, too, the fact that it can last 5 to 10 years. People get very fatigued, engaging in these processes as they drag on for many, many years. And it's also not working very well for the environment, I think, in a lot of cases. I think there are a lot of environmental rules that are at play here, but I think there's definitely some suboptimal outcomes that we've seen from an environmental standpoint too. So in looking at this, we really felt that we are not going to meet our greenhouse gas reduction limits without reforms to this process. So to address that, Governor Healy issued Executive Order 620, which established the Commission on Energy Infrastructure Siting and Permitting. The commission was required to advise the governor on 3 different things. So how to accelerate the responsible deployment of clean energy infrastructure through siting and permitting reform, how to facilitate community input into that process, but also ensure that the benefits of the clean energy transition are shared equitably. The commission was supported by a task force of representatives of different agencies that are involved in the permitting process, and also by a siting practitioner advisory group, which is a group of, I think, 11 or so attorneys with decades of experience in siting and permitting proceedings at the local and state level. The commission met 15 times over an 8-month period. We held 2 public listening sessions and had over 1,500 public comments received. I think there was over 20 members on the commission with representing a very diverse group of interests. And the commission submitted its recommendations to Governor Healy at the end of March of last year. As far as what the commission recommended, this is just a few things, but sort of some of the highlights. The commission recommended defining clean energy infrastructure and defining it as solar, wind, and anaerobic digestion facilities, energy storage facilities, and transmission and distribution infrastructure. It also recommended that we consolidate permitting processes at both the state and local levels. So trying to bring all these disparate permitting proceedings together into one common process. It recommended setting mandatory timeframes for issuing final decisions on permits. It recommended streamlining appeals processes. It recommended establishing community engagement requirements for developers. It recommended providing support for municipalities and organizations to engage in these processes. And lastly, it recommended creating some guidance around the suitability of sites for future energy infrastructure development. As far as what that resulted in, so the commission's recommendations formed the basis for the development of proposed legislative language, which ultimately made its way through the legislature and was signed into law in November by the governor. And so now we're moving into the implementation phase. So as far as what's in there, there's sort of 2 tracks that I would identify. One is consolidated state level permitting. So this is all state permits. And in the case of large infrastructure, local permits would be issued by the Energy Facility Siting Board. This is a model used in lots of other states. Connecticut, Rhode Island, New York all have various forms of this in particular. And Massachusetts actually has this today too. The Energy Facility Siting Board, through the process of issuing certificates to projects, can actually issue any state or local permit that a project may be having a challenge getting a final decision on. But what the recommendations do here is it consolidates all of these permitting processes into a single proceeding at the Energy Facility Siting Board. So large generation facilities, those above 25 megawatts, energy storage facilities that are larger than 100 megawatt hours, any offshore wind related infrastructure that's onshore and then or in state waters, and then any large new transmission projects, all would be required to go through the Energy Facility Siting Board. The board may review certain other projects in certain cases, but these types of facilities would be permitted exclusively by the board. So any facility that seeks a permit would submit an application to the Energy Facility Siting Board, and then all state and local agencies that otherwise have a permitting role would be automatically eligible to intervene and then participate by issuing statements of recommended permit conditions. All projects would be subject to a cumulative impact analysis as part of their application, and then permit decisions would have to be issued within 15 months with decisions appealed directly to the Supreme Judicial Court. On the local side, municipalities and regional commissions such as the Cape Cod and Martha's Vineyard Commission would retain all permitting powers, so the permits are still issued at the local level. They can continue to run separate approval processes, so Conservation Commission, zoning could be run independently. But what they would be required to do is, at the end of that, issue a single decision. So they sort of bundle these different reviews together into a single thing issued by the municipality as a whole. That permit decision would have to be issued within 12 months. Local governments can refer a project directly to the Energy Facility Siting Board if they feel they don't have the sufficient resources to review it. So this can go straight to the state if a municipality doesn't feel it's capable. And then permit applications can also be reviewed by the Energy Facility Siting Board if someone wishes to seek a fresh review or de novo review of a local permitting decision. And the DFSB would review it to determine whether the decision was made consistent with state law. And then the last piece here is that the Department of Energy Resources has been given the authority to establish standard municipal permit applications and uniform sets of baseline health, safety, and environmental standards that would be used by local decision makers. So they're going to engage in a rulemaking process. They're creating a new division, and that will establish some parameters under which municipalities would have to issue these consolidated permits for clean energy infrastructure. As far as community engagement is concerned, there's a formal establishment of the Office of Environmental Justice and Equity in statute with a specific requirement that they develop guidance regarding community benefits and cumulative impact analyses. There's first ever mandatory community engagement requirements that will be developed by the agencies promulgating these rules, including documentation of efforts to involve community organizations and demonstration of efforts to establish community benefit agreements. There's a new division of public participation at DPU to assist projects, to communities and applicants with engagement and process questions as it relates to DPU and Energy Facility Siting Board proceedings. A new division of siting and permitting will be established at DOER to assist communities and project applicants with questions around local permitting as well. And then importantly, there's an intervener financial support program that's available to under-resourced organizations and communities that wish to participate in an Energy Facility Siting Board proceeding and receive intervener status. So an example here might be a small municipality that doesn't typically engage at the Energy Facility Siting Board would be able to apply for funding, financial assistance to hire expert witnesses, attorneys, and the like to fully engage and participate as a party to a siting board proceeding. And importantly, actually can thank Senator Comerford for this suggestion, municipalities with a population under 7,500 or less are automatically eligible to receive financial support. So if a project is coming through a municipality that has a population of 7,500 or less, and they seek financial support and intervener status, they would be granted that status and granted financial support automatically. Just wrapping up here, some additional reforms. As I mentioned before, EA is required to establish a site suitability methodology that will inform state and local permitting processes around the suitability of sites for clean energy development and is designed to help developers avoid, minimize, and mitigate environmental impacts. There are 5 new seats on the EFSB. So 2 that have been replaced, but there's 5 new ones here. So the Department of Fish and Game, the commissioner's on it. The Commissioner of Public Health is on it. The representatives from the Massachusetts Municipal Association and Association of Regional Planning Associations. And then lastly, a representative with expertise on environmental justice and indigenous sovereignty. There were some permit extension provisions in here that allow projects that have been delayed by interconnection to retain local permits until interconnection upgrades have been built. There's some provisions for the transition period that allow large energy storage projects to seek Energy Facility Siting Board certificates prior to the law taking effect. There are, importantly, projects that are going before the Energy Facility Siting Board will no longer also have to go through MEPA, but the MEPA requirements will be embedded within the Energy Facility Siting Board jurisdiction. And then some legacy DPU siting authorities, particularly around comprehensive zoning exemptions and eminent domain, will be transferred to the EFSB. So there won't be 2 different entities with siting authority at the state level anymore. Everything's going to go through the Energy Facility Siting Board. And then just wrapping up here with just a couple of slides just to sort of illustrate this, and then some next steps. So I've talked a little bit about there's the different tracks for small versus large. And so you can see here on the left, this is the current process as things exist today. So small projects that do not have to seek an approval to construct at the Energy Facility Setting Board, they just have to go through individual state and local permitting processes on their own. So we identified there's potential up to 15 or so different permit paths that they may need to pursue individually. That's typically not the case for small projects, but there's still several different permits and approvals that they would require. And each one of those has a separate decision-making process, a separate appeal process. There are no definitive timelines for any of these things typically. So some of this stuff can drag on for many, many years before it even gets to a decision. Then it can go through multiple layers of the court system as it winds its way to get appeals. For large projects, they have to do all that as well, but they also have this added step today of having to seek approval to construct from the Energy Facility Siting Board. So moving over to the right, and this shouldn't say recommended process, this is just a slightly outdated graphic. This is the new process that is now law. But you can see here, small projects submit a single application to the municipality. The municipality shops that out to various boards and that within the town that have to issue separate approvals, or they could combine those processes into one. It's kind of up to them. But then that would all come back together in a single permit that's issued, or just final decision that's issued within 12 months. It could be a denial of a permit. There's an optional 6-month review of local permits by the Energy Facility Siting Board. So if someone is aggrieved by the municipality's decision, they can seek review at the Energy Facility Siting Board. And if people don't like the decision at the Energy Facility Siting Board, they can appeal that directly to the Supreme Judicial Court. So that's the process for small projects. For large projects, it's a single application to the Energy Facility Siting Board, a single proceeding in which all parties engage, and a single permit decision issued within 15 months or less with a single appeal to the Supreme Judicial Court. So a significantly streamlined process for those larger projects, but everyone knows exactly where to engage because it's all in that one consolidated proceeding. And I'll just conclude with this next steps here. So the law requires that regulations be promulgated by the agencies that need to by March 1st, 2026. EEA, the Department of Energy Resources, Department of Public Utilities, and Energy Facility Setting Board are all actively developing implementation plans right now that we're reviewing internally. EEA has issued a solicitation to hire a consultant to assist with developing cumulative impact analysis and community benefits agreements guidance that they have to develop. And then there's a staffing needs at each of these agencies, particularly at DOER, where they have to create a new division. So they've begun that process of recruiting new staff. And actually earlier this week, DOER posted a position for the director of the Siting and Permitting Division that they'll be standing up. We expect some initial public engagement processes will begin next month. So there'll be more information on that to come soon. And we've established sort of it's a bit of a skeleton page right now. There will be much more information on this as the process unfolds, but there's more information on the process can be found on at the link that I've provided here. This is a page on EEA's website that will sort of consolidate all the different processes into one location and provide opportunities for public input and questions. So we just literally created this a couple days ago. There will be more information posted as it becomes available, but it's the place to go if you have any questions about this process or where things stand. So with that, I'll wrap up my presentation, and I think I'm going to turn it over to Senator Comerford and Representative Blais, who are going to take it from here.
Thank you, Undersecretary Judge. It is great to be with you here today. And thank you to TNC for convening today's webinar. It is good to be here with you all. My name is State Representative Natalie Blais. I am honored to serve the 1st Franklin District since 2019. This district includes 18 communities in Franklin County and is over 450 square miles. It is one of the most rural, if not the most rural district in the Commonwealth. I am proud, very proud to be a part of a legislature that has advanced not one, not two, but 3 comprehensive climate bills since I first took office. I'm extremely grateful to Speaker Mariano, Chairman Michaelowicz, Chairman Roy, for prioritizing legislation that tackles the climate emergency that we are facing and ensuring that we are taking the steps necessary to meet our climate goals. I would be remiss in talking about climate emergencies without acknowledging what is happening right now in California and say that our hearts go out to those residents who are facing really unimaginable losses as a result of the wildfires that are burning there. I'm really grateful to be a part of this discussion today because many, many constituents were in touch with us as this law was being considered by the legislature. Our communities, our constituents have been pushing for this transition to our clean energy future, and we have heard you loud and clear. Your voices have traveled across this entire Commonwealth and have really pushed us to do better. And living in one of the most beautiful parts of our Commonwealth with forests and fields, fresh waters, streams and rivers and lakes and mountains and more is truly a privilege. I'm honored to represent these 18 communities in Franklin County alongside my good partner in so many of these efforts, Senator Joe Comerford, and I will turn it over to you, Joe.
Thank you, Representative Blais, Natalie. Hi, everybody. I'll start by also thanking Undersecretary Judge, not only for your presentation, Undersecretary, but for being so available to and engaged with so many across the Commonwealth, before, during, and now after the commission. You've been really exemplary in your ability to take in information and really listen to the concerns of the people that Natalie and I work for. Thanks also to the Nature Conservancy for your work on the commission and for helping us really engage deeply in protections for natural and working lands. Undersecretary Judge, you were kind to shout me out, but really I do nothing without Natalie and without my Chief of Staff, Jared, and great advocates like the Nature Conservancy. And I also want to add my thanks to the Senate President and Chair Rodrigues for sticking to a commitment to climate. We know we have to do more. And Senator Barrett, Mike Barrett for our side of the aisle, tells us about this all the time. And I'm grateful to Mike for really digging in on some of the protections that Rep. Blais and I are going to talk about today. And I just want to echo what Rep. Blais said about the disaster in California. One of the things that we all have to do is both dive into the immediate climate crisis, and I know I'm talking to people who are engaged in this work, but then also really think about how we protect people. So I want to thank Governor Healy, Lieutenant Governor Driscoll, for really putting forward the first ever disaster relief program in the Commonwealth. And it was, a result of a climate crisis that happened in Western Massachusetts and across the Commonwealth in 2023. So our hearts are in California, and I'm grateful for the protections here. The municipalities and the constituents I represent, like the ones that Rep. Blais represent, are urgently concerned about climate change. They want to participate in the clean energy revolution yesterday, today, and tomorrow. They want energy infrastructure that's going to power us forward. We just need to, and that's our job in the legislature, working in partnership with the administration, make sure that we're citing this smartly and equitably, and that we avoid forced and false binary choices. We can either have green energy or save our natural and working lands. We need both, and we all know that we need both. So I'm going to start this slideshow. Rep. Blais and I offered a few slides, and we are going to duplicate some of what Undersecretary Judge said, but we wanted to put the information that we found most helpful from the law into a problem progress kind of paradigm so that municipalities can understand the way in which we were hearing them and the administration and the advocates were hearing them and what we were doing to try to take the next steps. So here we go. I'll start the slideshow, Nat, and then we'll go forward.
Thank you for your technological expertise, Senator.
Well, I think you're saying way too much. Okay, again, a few slides, and I'll go first, and then we'll tag team as we often do, Natalie and I. So first of all, we hear all the time out in Western Massachusetts, our forests are key. We value them, we steward them, and we sacrifice for them. That too many trees are being cut down to site solar. So this new law requires. And again, shout out to the Nature Conservancy and the administration that all siting and permitting decisions avoid, minimize, and where it's not possible to avoid or minimize, we mitigate the impact on the environment and the land. That's really important as a guiding principle. Also, one example of avoiding and minimizing is that utilities in this law will be mandated to deploy grid enhancing technologies, which could and hopefully will cut down the need for new infrastructure, new cable lines. We also say that siting solar on the built environment out here should be a higher priority than taking natural or working lands, right? We hear that all the time. So this actually goes right at that, this law, and it says, okay, so we're going to consider additional incentives for solar canopies on built and disturbed land, right? So we're going to do that even as we contemplate other projects.
Thanks, Joe. Yeah, as I mentioned in my opening comments, I represent 18 communities here in Franklin County, and we know that small rural communities benefit from the tireless efforts of volunteers. And our municipal staff are stretched so thin, and they are working countless hours in support of these communities. Our municipal capacity is often limited by part-time staff without dedicated grant writers, engineers, planners, and we have incredible regional planning agencies like the Franklin Regional Council of Governments, the Pioneer Valley Planning Commission, the Berkshire Regional Planning Commission, who are working really hard to fill these gaps and support our small towns, but they too are struggling with a lack of capacity. Secondly, I just want to recognize that too much energy infrastructure in one municipality is not our goal here. It cannot be our goal here. We are all partners in the Commonwealth's efforts to meet our climate goals, and I am very mindful of balancing the siting of decarbonization infrastructure, the protection of our natural resources, and the impact on our small rural communities. So the problem that we've seen in our communities is that energy infrastructure is being proposed for inappropriate areas, and some towns are fielding numerous applications that will result in too much energy infrastructure in one municipality. So this new law does enshrine into law the Office of Environmental Justice and Equity, which will help to develop a cumulative impact analysis, setting standards, ensuring that all have access to a clean environment. Would also create a methodology and guidance, these standards to evaluate whether a site is well suited for hosting energy infrastructure. And it is noted that a methodology must be developed and guidance developed to evaluate if a site is well suited for hosting energy infrastructure, and that it considers climate change resiliency, carbon storage and sequestration, biodiversity, and these social and environmental benefits and burdens in that methodology.
Thanks, Nat. Here's another issue that we hear a lot more about. I think not only Rep. Blais and I, but certainly our colleagues across the Commonwealth. Constituents want us to do more to address carbon emissions before we get to ground-mounted solar, right? This is the same vein as we should site solar on the built environment or disturbed land before we hit natural and working lands, right? So these are some of the values that we are bringing to the fore. So this law goes at the next generation of this work, and it's this work that Rep. Blais and I have been working on. We started with a net zero stretch code when we were first in office. That is now law. And on top of that, we have an embodied carbon coordinating council, which is, we're working with the AIA, the Association of Architects statewide, and many other advocates to say, okay, so our buildings not only do they have to be clean and green? They actually have to do better in terms of the materials they use and the carbon that may be emitted from those materials, and what can they do to store carbon themselves? So this is the next generation of honoring the work of carbon sequestration as part of this plan that the Commonwealth has. So again, we'll get more green energy, and we're going to do better about storing carbon. And with that in mind, this law doesn't tackle things like updating pilot formulas or thinking about a no net loss policy for forests and farmlands. It's important for constituents to know that both the administration and the legislature are considering that kind of legislation as well. So I'll flip to the next slide.
Yeah, there is so much happening, and that has happened. You know, we've been able to introduce really innovative laws in the Commonwealth as a result of what we've heard from you. So here we have this problem of, you know, municipalities having had solar siting and battery energy storage siting bylaws struck down by the Attorney General's office. Many of our communities have spent a great deal of time, hours and hours upon hours of volunteers working to develop these solar siting and battery energy storage siting bylaws, you know, only to have them struck down. So this new law does begin to address this issue by enshrining into law the Division of Clean Energy Siting. This is a division that will provide new support for municipalities as it relates to technical support and assistance. And I do want to say this is a direct result of us as legislators, you as community members, and certainly our municipalities saying, we need this assistance. We need this technical assistance from the Commonwealth if we are going to move forward in meeting our clean energy goals. And this division will establish standard conditions, criteria, and requirements for the siting and permitting of small clean energy infrastructure facilities by local governments.
Here's another issue that we hear a lot about, which is that, and Natalie's already talked about the kind of lean and mean town governments that are really emblematic of rural communities, right? So smaller municipalities, we don't have the resources or the capacity to engage with developers on a level playing field, or to engage in the DPU and EFSB proceedings that Undersecretary Judge talked about. I think of this as like a David and Goliath kind of issue, right? How do we, in a community of 700, 1,200, 2,500, how can we ever engage on a level playing field? That's real. And the administration and the legislature heard that. So along with a consolidated process and a time clock, there's also an agreement that municipalities will receive additional time to conduct the permitting if a developer's application changes. And what does that mean? It means that we know, and the administration knows, the legislature knows, and you know, that often a permit can or a proposal can change. And it's really difficult for us, especially a small community, to pivot and understand what that change means. So there is more time afforded in the process if something like that happens. Another new division or new entity created is this Division of Public Participation, which is going to be fully responsible for assisting people and local governments and organizations with navigating these really complex processes at the EFSB or DPU. And then Undersecretary Judge talked about this. For the first time, there's funding, actual dollars, to assist with intervening in these processes. And it's really important, I think, and I hope we all agree that communities with fewer than 7,500 residents are not going to need to demonstrate financial need. They're just going to be understood to need these additional financial resources in order to engage, again, on a level playing field. I think that's it. So this is Natalie, and we'll send these out. This is Natalie, this is me. And thanks for the opportunity.
Terrific. Thank you so much, Undersecretary Judge, Senator Comerford, and Representative Blais. that was really comprehensive and really helpful. And I hope that the main takeaways people have are that this is not your father's energy grid. This is a different approach. We have different environmental criteria. We have requirements to avoid, minimize, and mitigate. We have enhanced community engagement, and we have a process to weave those two together. And we also have a different process where the energy developers will be working on pre-filing. Before they drop a permit on a community, they have to engage with the community and hear about people's lived experiences. And then they also have to look at the site suitability guidelines that are being developed. So I'm seeing a couple of trends among the questions, and this might be a more appropriate question for Undersecretary Judge, but I encourage other of the state legislators to answer as well. So one of the things to think about when we're transitioning away from fossil fuels is the infrastructure needed to meet that. But another thing to think about is how do we reduce demand for energy in the first place? And what's the state doing about that? And then what is the state doing to drive energy development to the built environment and avoid the impacts on nature and people? So two ways that we can reduce the need for building more infrastructure.
Yeah, okay, I'm happy to answer that. So I'll start with the kind of reducing demand. I'd say reducing demand is maybe our top priority. So if we can avoid adding demand to the electric grid, that avoids the need for additional infrastructure. So we don't need to site as many generation facilities. We don't need to site as much utility infrastructure. There's also the prospect of optimizing existing infrastructure. So an important aspect of the Climate Act that was just signed is it requires utilities to make demonstrations that when they're proposing new infrastructure projects, and actually this is actually in the siting provisions, that they considered grid-enhancing technology alternatives. So these are technologies that can avoid the need for maybe a new transmission line or transmission line of the capacity that is being proposed. This is historically not in the financial interest of utilities because they make money off of making investments in infrastructure. So they would be required to make this demonstration. We are also examining ways to change the way that they are compensated for their work in this space. So encouraging them to optimize, giving them performance incentives to optimize the use of their existing grid rather than just building new infrastructure. So demand reduction is like central to what we're doing. I would also add the Mass Save program, our energy efficiency programs. They've been nation leading. I think they were #1 in the country for 9 years in a row. They've been #2 for a few years since we're in competition with California on that. But we have some of the best energy efficiency programs in the United States. And we've actually reduced the amount of electricity that we've consumed since 2010 or so by about 10%. So energy efficiency and behind the meter solar has reduced statewide electric consumption as the population has grown, as the economy has grown, as we've become more dependent on electronics and other equipment. We've actually reduced the amount of electricity quite a bit. So we are consuming far less than we did in the past. But even despite all of that, the transition to electric vehicles, the transition to heat pumps, that is going to add demand on the grid. So we know there's going to need to be some expansion and additional capacity built. So I think it's a balancing effort in that regard. As far as trying to site stuff in the built environment, I would also add we are the national leader in this space too. We are far and away the leading state in terms of development of solar and other renewable energy resources on landfills and brownfields. The EPA has cited Massachusetts as being the national leader in this space in a number of different forums. I think more than a third of and we're not a very big state geographically, but more than a third of all solar facilities sited on landfills in the U.S., at least last I checked, were located in Massachusetts. And Massachusetts is also the leader in the continental U.S. in terms of per capita deployment of behind the meter rooftop solar. So we actually have more distributed solar resources on our electric grid than any other state in the continental US. Only Hawaii is ahead of us, and only by just a little bit. So I think we've made a lot of efforts to really encourage responsible solar siting. But the reality of the situation is that we cannot get there by just putting it in the built environment alone. There are obstacles in the built environment that will prevent us from deploying solar there. So there has to be some sort of responsible land use policy. And I think we're trying to get at that with these siting and permitting reforms. But we are also reforming our incentive programs, the SMART program, and looking at how we provide incentives to solar through a kind of a different lens. DOER actually just put out a straw proposal on that last month, and is going to be developing regulations that will go out for public comment probably in the first half of this year. I don't know. I don't want to commit to like a specific timeline just exactly, but in advance of these permitting rules. So we're trying to develop those incentives in concert with the permitting requirements so that they work together, and that we're really encouraging solar and other types of clean energy in the built environment over open space, over sited in kind of open space or less developed areas.
Steve, if I could just say one quick thing. We've talked about these incredible, dedicated, smart volunteers that we have in our communities. Our energy committees are doing incredible work in our towns. And so I just want to make sure that we recognize their efforts. And Aaron Fallible from Sunderland has reminded me often that one of the easiest ways for us to reduce our energy needs here in the Commonwealth is to take on individual changes in our individual lives and how impactful that would be. So I just want to make sure that we say thank you to our energy committees in our communities and those who are doing this work in our neighborhoods.
Terrific. Thanks so much for that detailed answer. It's really heartening to hear of all that. Plus, there are building codes too.
Thank you for mentioning that. I forgot to mention that. We do have kind of some of the most stringent building codes in the country as well. And in particular, the new specialized energy code, which I think 30% of all residents live in a town that has adopted the specialized code. And then it's only 8% of only 8.5% of residents live in a town that is just using the base energy code. But even the base energy code is actually pretty efficient in Massachusetts. But the remaining municipalities have new energy code requirements that should keep new construction, demand from new construction to an absolute minimum. I mean, the way our energy efficiency engineers who are working on this code describe it is they call it crushing energy demand. I mean, these new construction is in many cases being built to a passive house design with almost virtually no need for any kind of on-site thermal heating needs. So you have very, very minimal needs from like an electric consumption from new construction, but retrofits of existing infrastructure is a little more challenging.
So there have been a couple of questions about how municipalities prepare and what rights municipalities have. As our two legislators have mentioned, a lot of the communities are very low capacity. They're volunteers, even though we have some really sharp people on energy committees and conservation committees. A lot of these folks are volunteers. So what are the best things that folks at the local scale can do to prepare, number one? And then number two, there was another question. If a community wants to push back and deny a permit, what does that look like?
I can start. So I think we have not yet begun our full sort of public engagement process because we've spent the last, it was the holidays, also spent the last month and a half just kind of preparing sort of our implementation plan at the agency level. And so we will soon be coming out with some more resources and questions for comment to municipalities and other interested stakeholders. I think we're committed to making sure that people are in the loop about what's happening and when they should be engaging and providing input into the process. We're going to be doing some public engagement sessions probably in late February, early March. There will be other processes that the agencies that DPU and DOER are going to be establishing as they develop their rules. So I'd say stay tuned. That website that I provided a link to in my presentation, that's a good place to go to. We're going to try to post materials to that. And as DOER in particular stands up its new division, they'll have staff resources that you can reach out to and actually ask questions. We'll also be creating an email address where people can send questions and we'll route it to the right people. So more to come on that. I wish we were a little further on, but we're pulling those pieces together, and I'll make sure that presentation is available to folks so that you can see that link.
Before you answer the second question, I would also say that the Clean Energy Extension at UMass has some great resources for municipal officials to dig deep, and especially the presentations that were done at the seminars and the gatherings they provided. That's a really great place to go.
Yeah, and I think we will also be working through regional planning associations and the Mass Municipal Association. We'll be making sure to work closely with them so that they can be disseminating this to their members and to the communities that they work with, so that people are staying in the loop that way.
So maybe just elaborating a bit on the other question, what does the municipal process look like? We talk about a consolidated permit. Is there one board or entity that's in charge? What does the process look like when a community is doing a consolidated permit? And can, if a community wants to set stipulations or push back or say no, what does that look like?
Yeah, I think that's still a little bit to be determined because, there's this whole process that DOER has to develop that has not yet fully commenced. But the way that I might envision that working is there's probably going to be someone identified within the municipality who's sort of like the point person who then disseminates this to the respective local committees. So we receive this, like, say, okay, hey, we just received an application for a consolidated local permit. Here's the application. Zoning board, you need to review this. Conservation Commission, you need to review this, and kind of disseminate it to the various folks. I don't know exactly who will be that central point of contact designated, and at this point in time, I think that's something DOER is going to have to work with municipalities on to determine what's the best way to route this to an individual so that then it gets disseminated within the municipality. And then as far as stipulations and requirements that they can place on it, again, I think to be determined still. But one thing I've been pointing out to folks is that existing state law does not allow municipalities to unreasonably regulate the zoning of solar unless it's for the purpose of public health, safety, or welfare. And this has led to a lot of consternation at the local level. There's been a lot of municipal bylaws that have been reviewed by the Attorney General's office and found to be non-compliant. There's been cases that have gone all the way up to the SJC. So we've seen a lot of points of friction around this issue. And one thing that this law does is it allows DOER to establish standards that could be environmental in nature. And so as an example, I'm not saying this will be the rule, but let's say a community has hosted a significant amount of ground-mounted solar, say 50 megawatts or something like that already. And they are concerned about a new project that's coming in that's going to involve some kind of land use change. The rules that DOER establishes may actually permit that municipality to say no, or push back, or impose different types of restrictions, or collect mitigation funds from that project if it's disturbing some land in the community. That's not allowed under state law today. So that's that. I think just the opportunity that this creates for municipalities to potentially impose new types of environmental standards That's something that's on the table here that will be a discussion that's borne out in the regulatory process that DOER is going to conduct. But that's, I think, something that people should be paying attention to, is that DOER has the ability to set standards that help clarify what that existing provision in state law means when it refers to unreasonable regulation. So, because I think that's been a question that has only been able to be decided by the courts to date, and now DOER has some authority to put some definition around that.
That's great. Thank you so much for answering the questions. And I know we didn't get to everyone's questions, so I appreciate everyone's patience. We did our best to try to consolidate and configure the questions. So we're approaching the end of our time today, and I just want to express great appreciation to our three panelists. You've been really informative and generous with your time, and I just want to offer you up an opportunity to have some final words. And maybe we'll start with Senator Comerford first, go to Representative Blais, and then Undersecretary Judge.
I'll just jump in. I want to go back to the good questions about, how the heck is this going to happen? Which is what we hear all the time. And really listen deeply to what Steve and Natalie and Undersecretary Judge just said, which is there are numbers of bodies in our Commonwealth, like MMA, like our regional planning agencies, like UMass Extension, that are both known to and valued by the legislature and the administration, and they will be integral to the rollout of this. And it's really hard, and I understand how hard it is to grapple with the unknown, and especially when the stakes are so high for so many of the people across the Commonwealth. So, and I would just put legislators in that bucket as people who are tuned in both to the implementation of this, but also in the implementation of what's to come, right? The new laws and the associated laws, like we talked about today, net zero, pilot, free bus fares, right? All of this are in the climate space, which are, I think we have to see them all as interconnected. So thank you so much for the opportunity.
Absolutely. Representative.
Thanks, Steve. And thank you again to everybody. To have 250 plus people here today is really extraordinary and really shows how much you all value our climate. So thank you again to TNC for having us, for hosting us, for bringing us all together. I just want to end with complimenting and really lifting up this administration that I know is going to prioritize public input going forward. Undersecretary, you've talked about this, the fact that you'll be having listening sessions, the fact that you will be listening to our communities that have been talking with us daily about this bill and about climate generally speaking. So I just want to really thank the Healy-Driscoll administration for being so accessible. It's really extraordinary, and just want to thank you for that.
Great. Thanks, Representative. Undersecretary.
I just want to thank the Senator, the Representative, and the legislature in general for their partnership on this. I think this is going to be a complicated process to get all these regs together, but we're committed to doing it right. We're committed to making sure that people feel heard and have input in the process. And it's our top priority for this year. So we are, there will be more to come. I wish I had more details to share today, but there's definitely a lot more to come on this topic. And we really appreciate everyone being so involved and so interested in it. We want to make sure that your voices are heard as we develop these rules.
Well, thank all three of you very, very much, not only for today, but for all of the work and due diligence you have put into this effort. I'm really excited to see the new environmental standards and the enhanced community engagement. So I just want to thank the audience too. Thank you for joining us today. Thank you for your thoughtful questions. And thanks to folks who support TNC so generously. We really, really appreciate that. Great partnerships all around. So just a logistical thing, we'll be sending everyone a follow-up email over the coming days with a link to a recording of this webinar. And if you enjoyed this webinar, please be sure to share it with your friends and colleagues. You can follow us on social media at conserve_, MA on Facebook and Instagram to keep up with our work and get updates on upcoming virtual opportunities to connect with us all. As always, you can register for future webinars at nature.org/MA webinars. And our next webinar will be the last installment of our series on offshore wind. So please join us on January 23rd at noon Eastern Time, where we'll be talking about community benefit agreements and offshore wind. You can learn more about the series and view the recordings at nature.org/offshore wind. We hope you can join us then. Thanks again, and I hope you have a good afternoon. Take care, folks.